Okay. Hi everyone, and welcome to this final session, the grand finale of this two-day event on sustainability and global economic law. Let me introduce the panelist, Christina Eckes, professor of EU law and director of the Amsterdam Center for European Law and Governance. She is currently the academic manager of the Sustainable Global Economic Law. And then Ingo Venzke is who's professor of international law and social justice at the Department of International and European Law and the director of the Amsterdam Center for International Law, which is also involved in the SGEL project. Maria Bartol, who is professor of private law and director of Eckes, the Amsterdam Center for Transformative Law, which is also involved in SGEL, was also supposed to attend this panel, but unfortunately she couldn't join us today. So for this last session, I asked Ingo and Christina to offer some concluding remarks and share some thoughts about the conversations that we've had yesterday and today, how that resonate with their work and their vision of SGEL. So I'm gonna give them the floor. You have 5 to 10 minutes, and then we can have a sort of open it up and have a conversation all together. Christina, do you want to start?
Sure. Thank you, Ivana. Yeah, thanks first of all for a brilliant conference, a lot of interesting discussions. So very difficult to start somewhere, particularly on a Friday afternoon where everybody thinks about us as the obstacle to the weekend. So I want to start with an anecdote, as at some point I've been told is a good speech. You should start with an anecdote. So for those of you living in the Netherlands, you're aware that we can choose a new health insurance every time at the end of the calendar year. So yesterday evening was my moment to do so. And I was checking out different health insurances on a website that compares them mainly with regard to consumer interest. So what do they cost? What do they offer? Whatever. And I came quite quickly down to, ORA and Zorg and Zekerheid. Sounds already good, care and security. And then I checked them out on a different website, namely the Eerlijke Verzekeringswijzer, so something like the Just Insurance Compass, if you like. So a website that compares by no means what they cost or how well they answer their telephone or these sort of things that are relevant to consumers, but where do they invest their money? And both ORA and Zorg and Zekerheid stood out for investing their money in things like weapons, fossil fuel industry. And I was very, how shall I say that? I put it, of course, in the context of yesterday's conference and the many facets of that, the many nuances of inequality and sustainability, how they come together and how you read them. Because the simple choice against weapons and fossil fuel industry cost me 900 euros a year. And I thought that was a quite interesting fact, next to the fact that the first website did not have any indication of these sort of questions, namely, what do they do with their money? And I think what it made me think of is that there was a lot of agreement in yesterday's conference. So that was my mindset yesterday evening. Agreement on the relevance, obviously, of sustainability and inequality, the agreement that there are a lot of problems with both concepts in these situations. And I mean sustainability now in the sense of environmental and climate issues and social justice issues as points of inequality. And in our discussions, we discussed, of course, the definition of value. What is the economy? How much of the non-economy? What is economic and how shall we divide it from non-economic? Does it make sense, or do we need a completely new system? And how dominant concepts of value are colonized or cannibalized was even the word used by how do economic concepts cannibalize non-monetary value production, we had all these abstract discussions and questions of which economic processes are privileged and suppressed, and which groups are racialized. And I must say I found it inspiring and also at a conceptual level very interesting. And I was wondering, so where in all this should we make a contribution, we as sustainable global economic law? And I think, to me, that is really squarely linked to law. So what is the role of law in this? And I think that this by no means is not a criticism of discussing all the surroundings. I think we do need them to question what can law do, because we must first understand what the problems are. And they're of course in the law, but they're much broader and they require a conceptual understanding of the problem. But it also brought me back to Martti Koskiniemi's suggestion, namely that economists should become lawyers if they want to have a really interesting job. So in the sense that we must really think deeply about the black letter law and how it frames things. And we must take serious the point that law is a language and that we can use it to change that. And I think, in that sense, I think we are too much human rights lawyers. That's what I also conclude from what Martti Koskiniemi said, because he didn't say, I mean, not, as his point, and it's a point he has made before and at the Asa Institute, that we shouldn't become human rights lawyers, but of all lawyers, we should become investment lawyers. And I think that is what I concluded a tiny bit from the discussion, namely, we also need to engage more with the opposition. We must try to find the way, what can we do with law? And we must try to find ways to tap into discourses in which these concepts that we discussed are discussed very differently, even if that is an uphill struggle, even if that it's not always easy, or if you're marginalized yourself in that context, obviously, as a result of what we heard yesterday. And we also raised the question, of course, how can law be an instrument of change? How can economic law be an instrument of change? And above all, Katharina Pistor mentioned the uncertainties as an opportunity, let's say, as a space where law can make a difference. And she also mentioned the scaffolding and that you need to work in that, of course. And this also resonated in other presentations where it was maybe called fluidity or possibilities for reconstruction, but I think it's very close to this uncertainty. And what made me think in that context is our unique position that we bring together public law and private law, and that we don't make enough of that. Because particularly on that point, there is such a difference in how we look at uncertainties. I am, again, very much with the public law side. The first thing that comes to my mind is exactly what Martti said, that uncertainties empowers the powerful, because that's how I, as an EU public law person, first of all, thinks of it. I think of uncertainties, how they lead to more power for judges in the implementation, and how they lead to reconfirmation of those who argue these cases. But then, of course, the private law perspective historically on it is very different on that. So I think that is a point where we question where Katharina Pistor brought her point in, and also, I think it shows that this is a nexus where we can also contribute something that not every group has, namely these different perspectives on how we could maybe better than others put our finger on the question of, that's very Dutch, tease out where, how, and in what way uncertainties can be productive in the law. And what shall we do? I take the point that not everyone is an activist that was made, so that it's not maybe politically so difficult, but I think what we can do is exactly that. Let me try to step out of our own framing of, and I use the example of uncertainties or ambiguities. But one can also, of course, take the role of international law. We heard from Alessandra Arcurie, for example, the role of international law in climate litigation, and that it has a very productive role. And she was probably thinking of the Paris Agreement, not so much of the Energy Charter Treaty. And we heard from Marty how that actually can work exactly the other way around, if you like. So I think what we can do is, with our diversity that we bring to the table, really try to work out these nuances and where law can concretely, in concrete scenarios, do something, have an impact, move things forward. And yeah, I must say, this bringing it maybe from the clouds to the ground is where I think that also, yeah, deep research and PhDs, research that takes time and that has a high academic standard can move us forward and can bring to the test all the concepts that we discussed in many ways. All the test also, what can legal scholars contribute best to that debate? So I think one thing that we should try to do in sustainable global economic law, really, yeah, find that legal language and determine the meaning of these terms in a different way, in a legal context. Thank you.
Thank you, Christina. Ingo?
Yeah, thanks so much. So picking up what Christina just said, I think so that program of determining a meaning, doing also the black letter analysis, and showing the constitutive role of the law connects to that first strand in our project that you, Christina, also highlighted at the beginning. And so to carve out the constitutive role of the law with regard to socioeconomic practices that are more often unsustainable than they are sustainable. And I think there it really connects. And you also said that there's quite a bit of agreement in the group. So I'll try to feign a little bit of disagreement here and say that that works well with regard to the first strand, but perhaps not so well with regard to the second strand, which is to try and see what the possibilities of transformations are of the law and of the socioeconomic practices that they co-constitute. So it's two points that I want to highlight that I took away from the very rich discussions over the last couple of days with regard to each of these two dimensions. So first, with regard to the constitutive role, I'm quite in agreement also with what Christina just summarized. Maybe just to add on that, if anything, I think in the project we have really been stressing the need to see the law in this classically critical fashion also as part of the problem, right? So we've insisted on this need, against some pushback as well. I think here it's a fairly well shared starting point, but not necessarily so. And we insist on that for analytical rigor, but also for some degree of honesty, as it were. And also just because every other solution would otherwise be tried at best or just counterproductive at worst, if we weren't to start from that classic critical fashion of seeing the law also as part of the problem. And over the last couple of days, if anything, it's a little bit unsurprising, given who we invited, who we heard, who we cherish, who we like to learn from, that this sense of law's co-constitutive role in unsustainable socioeconomic practices has only become stronger, right? So it goes via particular fields, such as the protection of investors' legitimate expectations, which have been highlighted a couple of times. Jimena, Julia, and others have discussed that, to still deeper levels of the law's fixation with stabilizing possibilities to extract profit, and perhaps even a level deeper to see it as the law as an expression of demands of capitalism. That the two go hand in hand, that one cannot expect much from the former, from the law, unless the latter the capitalist social system was abandoned or suspended, at least locally. So that heightened sense of complicity, the contribution to unsustainable socioeconomic practices, of course, makes the second question about the possibilities all the harder. So I was a little bit reminded of some of the 12 critiques that have encountered a similar difficulty, right? So seeing the law as a relentless instrument of domination, but still wanting to vest their hopes, wanting to vest hope on the law, not as it's been or as it is, but as it could be. And it's also something that I've tried to get to or get at with the work on see in international law, how international law could have been different possibilities, alternative possibilities, where the difficulty has always been to carve out plausible alternatives that are, neither naive nor blasé, or not blasé, but that don't resign either, right? So I mean, it's constant tug and pull. So turning to that second strand, then to the possibilities of transformation. So already before the workshop, I've been thinking, like others before me, of course, and also others here who have participated as speakers or discussants and so on, that the way forward would perhaps be less so in a transformation of the law, of economic law, to turn it into a sustainable economic law. And that's where now a bit the disagreement might arise, let's see, into a, so that it be transformed into a sustainable variation, but rather, placing emphasis on rolling it back. So to illustrate the point with a bit of a straw man, occasionally I read that the awful asymmetries between foreign investors and home states in arbitration proceedings might be, well, not undone, but corrected to some extent, and the underlying asymmetries between economic and social claims that go hand in hand with that asymmetry, that they might be corrected by leveling up the host state, so to speak. Yeah? And that, I think, really, might lead to some improvements, but doesn't really cut it. That, to me, that doesn't seem to be the way to go. It's not really an improvement of the law, which I think in this particular domain is particularly hopeless. So they are don't transform, push it back. So no amount of reform is going to fix it. Fix that law's exploitative bias. You might still intervene tactically here and there, but I think the main strategy will not be one of transformation, but of pushback. That term, rolling back. But another illustration of that would be one where creative practices have emerged. I take one example. Julia Dehm has many examples in her work, but I take one example that I read from Sousa Santos in his Epistemologies of the South, where he mentions the example of Ecuador that has a lot of oil reserves, and made the proposal to keep them in the ground and to only ask half of the market price for those fossil fuels that are only in the ground. To say, look, I think it was about 4 billion that they could have, that they estimated these fossil fuels in the ground are worth. And they say, well, we keep them in the ground if you give us 2 billion. Yeah? Some of them were already promised or licensed, so there would have had to be a way of dealing with that, some of those assets. But what he says about this episode, I'm not entirely sure what happened with it. I presume not such good things happened in the way it unfolded. Also, given the reluctance of the global north, to commit to climate financing and so on and so forth, that they would pay for the fossil fuels to stay in the ground. Okay, fine, speculation. But what he makes with this is he uses it as an example. I mean, first of all, it illustrates the global bind that Philip and others also mentioned that a lot of the states in the global south are in, having to extract because of legal obligation, but also because of the debt bind, how to service debt without extraction, and so on and so forth. That's the example. But then the mechanism in response to say, okay, we keep them in the ground if you give us half the economic value, if you pay us off, so to speak, seems a pretty good bargain. It's only half. And if we don't extract, when we don't give away license, is in a way a suspension of the legal workings and operation. So it comes as an irritation that would push for a suspension. The rolling back may still go further, aiming at uncertainty, as Christina also mentioned with Katrina Pistor. And it may go further in reconsidering what kind of deals, what kind of economic interaction can ultimately count on the coercive force of the state, which then, of course, requires some radical lawyers in the relevant places to also there suspend and create some uncertainty and irritation and refuse the backing by the state. And I'm not so sure that there's enough radical potential there, but still, how would we get there? How would this rolling back work? And I think the rolling, so that's one question. Another point that I want to make with regard to the rolling back is the fact that it's not only to roll back where there's evident harm, but I think also it means the rolling back rather than transformation to question the hope that we may still place on the law as a vehicle to work towards something better. So it may well be that the struggle for a better law, for something like a sustainable global economic law, in any way in a reduced, already shrunken form, does not take a place. That struggle doesn't take place in the law, but that it takes place, as Isabel and others have highlighted, Alessandra as well, in local movements of commoning in alternative practices that may or may not come with an explicit challenge to the law, like the example of Ecuador, or not. It's just a suspension there as well. We do our thing, in parallel, so to speak, and hoping to push back a little bit there. So Lloyd's been argued yesterday, in particular, the law as we know it now rests on that separation between public and private, and the presumption of formal equality that on occasion has been emancipatory. So a lot of people have struggled to achieve formal equality recognition in the law, be it formal colonies, be it otherwise marginalized people, and so on and so forth. That has on occasion worked, but that formal equality, see above, has just been as deeply entrenched, implicit in wrecking people and planet. So in conclusion, I would say that the rather unbroken faith to pursue justice and sustainability, ecological justice in the form of law may also be part of the problem.
Great. This is great. Alicia, we can stop the recording now.